At this point, I want to introduce our next guest, John Froemming. He's going to explore civil enforcement. We've talked about criminal enforcement. We're going to move into civil and what you can do if someone is infringing your trademark. Now, John is a partner at Jones Day Law Firm in Washington, D.C. He specializes in intellectual property and advertising, and he's also a patent attorney, so wonderful. And he has represented a variety of clients in more than 60 different trademark and design trials and district court cases over the past 15 years. And guess what? He's never lost a case. Okay, so come on up here, John, who's going to share some information on civil enforcement. Thank you.
Thank you, and hi, everybody. I actually lost one case. It was a false advertising case, but thanks to great teammates like my previous colleague, the esteemed Judge Jessica Bradley, we have managed to win all the trademark cases. So the short answer to the question, what to do, is how to enforce. Appreciate the criminal enforcement remarks from the previous speaker. Very helpful to have that in context. As you may know, you're already taken a step in the right direction, because presumably you're here because you have a registration. Under U.S. law, in contrast to most other countries in the world, however, you don't necessarily have to have a registration to have enforceable common law trademark rights. But as Holly's probably already pointed out, there are huge advantages which you can already avail yourselves of. So let's take just a few minutes to walk through some basics with respect to civil enforcement. See if I can get this to go. There we go. All right. Have you all covered factors yet? Great, great, great. Okay, so regardless of what federal district court you're in or potentially could be in, each federal circuit has enumerated factors that district judges are required to consider in evaluating whether there's trademark infringement. And the basic test, once you've shown ownership of your trademark through your registration or otherwise, is a likelihood of confusion. What's important here is that you don't have to show an actuality of confusion in the marketplace, but you have to show something more than a mere possibility, all right? This is a list of factors, and it's not really a checklist or a list of requirements, in that you don't have to prove by a preponderance of the evidence that you ought to win with respect to each of these factors, and some are more important than others, such as strength of the mark, similarity of the marks, and so forth. But generally speaking, if you can tick through the list of factors and satisfy yourself, again, from an honest self-evaluation, that you've covered most of the factors your way, and particularly the most important factors, chances are you're in good shape to enforce your trademark successfully. Just a few words about these various factors. By the way, they do vary a little bit in their articulation and their nature from circuit to circuit. That can potentially become useful to you as a registrant, because if you uncover, God forbid, a serious infringement covering a variety of regions in the United States, and you feel as though you need to go to court or threaten to go to court, there may be benefit to you in having your cease and desist letter or your threat or your lawsuit be in or about the law of one particular circuit whose likelihood of confusion factors are more advantageous to you, okay? So for example, if you're in the Third Circuit in New Jersey, right, on their face, the likelihood of confusion factors look fairly pro-defendant. Again, it can vary from case to case, but it's a strategic or tactical consideration to keep in mind. So obviously, similarity of the marks is important. This is always a matter of degree, and it can depend upon the crowdedness of the field. That is, how many similar marks for similar goods and services are actually out in the marketplace in use. Because the more there are, the more similarity you may be required by the judge to show, and the more similarity you'll have to convey to your opponent if you're going to have a cease and desist letter be effective, and you can essentially get the result you want without a long, drawn-out legal battle. Some markets are crowded enough, and some trademarks are conceptually weak enough that there are circumstances where the mark you view as infringing is identical. It's an identical word mark, but it's not on the same or related goods or services. That's a situation in which there could be identical marks in the abstract, but no likelihood of confusion. So the mere fact that you see an identical mark could be helpful to you in terms of getting leverage, but it's not the end of the ball game. Relatedness has largely to do with a question a judge might ask herself, well, to the extent that the goods or services of the respective parties are not the same, are they close enough that a reasonable consumer could well think that the goods or services that the defendant potentially is in, the potential defendant is in, represent an area where you, as the registrant, are likely to bridge the gap, right? If you have a registration for copy machines, and somebody else is infringing with respect to toner or cartridges, right? You'd have a pretty good argument that this area of toner is within your natural zone of expansion of your trademark rights, even if you're not there yet. Strength of the mark is arguably the most important factor in some ways in terms of demarcating the breadth of your rights. The standard test is one of conceptual strength and commercial strength, right? You may be familiar with the spectrum of conceptuality from generic terms, which are completely non-registrable and unenforceable, to descriptive marks that usually are not enforceable unless there's some secondary meaning. There's some evidence from the marketplace or otherwise that when consumers see that descriptive mark of yours, they associate that with a single source, you, even if they can't name your company as XYZ Corp. They know, or at least 40% or so, roughly speaking, of the consumer market associates that with a single source, right? And then you go across the spectrum to more conceptually distinctive marks, to coined phrases, for example. Who would think of Apple in connection with computers, for example? Apple is a fairly distinctive mark conceptually for computers. So that's one spectrum to consider with respect to strength. The other is commercial strength, and that can be very important because if you have evidence that you've sold a lot of your trademarked widgets and or that you've invested relatively substantial amounts in advertising and marketing and promoting your registered mark on your widget, that can go a long way to helping you get relief. The general rule is that the scope of enforceability, the scope of protection that you can get for your registered trademark is going to depend upon the strength of that mark. The stronger the mark, commercially and conceptually, the broader the scope of protection you can expect, and the further you can go to single out and potentially go after people who are creating a likelihood of confusion with respect to marks that aren't only not identical, but maybe substantially different. So it's a pretty important consideration. In contrast to the criminal side, where intent has to be shown, one huge benefit of the trademark law on the civil side is that while intent of the defendant is a relevant consideration, and it helps you a lot if you've got evidence that they have a bad intent, right? You don't have to prove bad intent in order to prevail in a likelihood of confusion trademark infringement action. This is important because when we skip ahead to a potential cease and desist letter where you or your counsel, inside or outside, might send a cease and desist letter to the infringer and demand that they immediately stop using their confusingly similar mark on whatever the good or the service is, frequently the first response by the infringer is, well, I certainly didn't intend to do that. That makes for a pretty easy reply or, if necessary, lawsuit, simply pointing out that their intent is not insulating them from potential liability, and they need to move away from your trademark. Similarity of trade channels is another consideration. The mere fact that both your and your adversary's products are sold on the internet, or maybe even sold on Amazon, right, is generally not anymore a big deal that would hugely benefit you with respect to that factor. Everybody just about is in that space now. But if you can make a more particularized showing that the way in which your goods are marketed under your trademark through a distribution channel, through a specialized niche of internet commerce is the same as the way in which the defendant is distributing or marketing their infringing good or service, that can help you a lot. Frequently, particularly when it comes to the defendant's side, sophistication of customers can be a thorn in the side of a plaintiff, right? If this is simply a mass market product where the consumer doesn't spend a lot of time looking at the various options before grabbing it off the store shelf or otherwise, it's not a factor that's going to slow you down as a potential enforcer of your trademark, right? But if you're talking about very sophisticated equipment, for example, that is only sold at the wholesale level or only within a very sophisticated channel of people making semiconductor chips and so forth, where the good at issue is one that nobody buys without having to spend millions and spending months, if not years, researching first, that can be tougher. And so you have to do more homework there to try to argue, if you're on the potential plaintiff's side, that notwithstanding any alleged sophistication, the danger of confusion is real and likely. Actual confusion is also not required, particularly if you haven't been using your trademark forever, or if the defendant hasn't been using its look-alike trademark for a long time either. That's important because if, for example, you're launching or you just launched a product and along comes an infringer right away, there is case law you can cite to the effect that given how early you are in your life cycle of the product, that factor, the lack of any actual confusion, should not be counted against you in the Bisco case. On the other hand, if you do have evidence of actual confusion, whether it's anecdotal evidence of people sending inquiries to the other guy about how to service your product, right? That's anecdotal. There can be evidentiary issues, but that can be substantial help in your favor. Otherwise, consumer survey or likelihood of confusion survey is the common way that in more substantial disputes, plaintiffs who see something big at stake will potentially want to commission. Maybe not at the start of the matter, but as the plot thickens through after the filing of the lawsuit, particularly if there's a motion for preliminary injunction or the desire to get all the way to a trial. Finally, quality of goods obviously helps you. If your quality is great and the infringer's quality stinks, it shouldn't take a judge or an opponent who's being responsible long to figure out what's going on here, and that can be substantial leverage for you. That being said, quality per se doesn't have to be different, right? Some might say, for example, that McDonald's doesn't make the tastiest, the best hamburgers in the whole world. But when people go to McDonald's, they know what they're going to be getting because there's consistency. And they know that it's going to be a quality product even if it's not the best burger they've ever had. So the mere fact that your widget might not be scoring at the top of Consumer Reports for the quality, that shouldn't keep you from being able to enforce your trademark where there is a likelihood of confusion. All right, so you've just discovered that somebody is out there ripping you off. What do? Obviously, this is frequently discovered these days by seeing something on the internet. So the mere fact that you see something on a site that is really troubling doesn't mean that it's not going to be gone tomorrow if you don't preserve a record of that. So you want to be careful about that and make sure that you have it so that if the other side gets any inkling that you may be onto them, that they don't try to essentially make some cosmetic changes in an effort to insulate themselves from potential exposure to liability. Now, in contrast to most countries of the world, private investigators are generally available to help if it comes to making a test purchase of an infringing product so that you'll have the tangible evidence in hand of the product and how the confusingly similar trademark is actually appearing on that widget, right? Private investigators are allowed under U.S. Ethics and other law, generally speaking, to pose as a member of the public, as a consumer, right? So they can make a purchase like that, one benefit being that it's harder for the potential infringer to trace that purchase back to you, right? Where it becomes more problematic is that under general ethics law, you can't hire a private investigator, generally speaking, to try to entrap the senior management of the opposing company by engaging in some pretext to engage them in conversation in an effort to secure admissions that you wouldn't otherwise be able to get as just a member of the consuming public calling in or inquiring about the product. So, and that's particularly the case if the other side, if the dispute goes on and the other side is represented by counsel. I alluded a couple minutes ago to the great importance of conducting an honest self-evaluation at the start of this journey so that you can have a realistic view of your chances of success. In any organization where they feel that they've been beset, right, there is a natural inclination to feel like we've really been violated and we've got to do whatever is in our power to make a big deal out of this and to spend whatever's necessary to try to get a quick, early 100% victory, right? That can be laudable. Certainly the outside lawyers like that, but frequently there's more to the story. So it's better up front to do this honest analysis and find out if there are any warts or any skeletons in the closet, to mix metaphors, so that you can factor that into your analysis and advise your management or your client more realistically about the likelihood of success and how you're going to meet those challenges as you're usually able to do. In terms of intel, obviously it's helpful to know whether the potential defendant is infringing other people's goods. Maybe this is an industry-wide problem and you may be able to share the burden with other people with whom you normally compete, but who might have a common interest in going after a really bad character. Then too, Holly, I think, spoke earlier today about social media and platforms and so forth. It may be that your least expensive but sufficient remedy here is to complain to Amazon or complain to some other platform that is hosting sales with a small h of the infringing goods. That can frequently be a quick takedown and spare you a lot of the expense and uncertainty of what a trip through the federal court, district court system can be. Again, ask yourself, is this a local problem? Is this a mom and pop who's ripping you off? Or is this a national problem? Is this an international problem? In which case, where's the best pressure point? Is it here? Is it in Europe? All important considerations. So once you've done all that, if you concluded, okay, this is serious, and we need to consider hiring outside counsel, you've got a great variety of options. The level of knowledge, experience there of trademark lawyers and litigators out there varies widely. You can find local practitioners who are relatively inexpensive at relatively $300-400 an hour. But if it's important or complex, involves big stakes, you can easily find ways to spend $1,400-1,500 an hour for good counsel. But I can tell you, they're worth it. And then another consideration is, okay, well, let's say you've gone through this process. Do you give notice? Do you immediately fire off a cease and desist letter to the other side to put them on notice that you're on to them, you've got this registration, they need to stop immediately? Sometimes that's the best and most efficient course, right? But there are considerations. If the other side has a lot of means and it would appear would be willing to litigate over it, you need to be careful about that, because if, as I mentioned, there are some variations of relevance between the law of the circuits where a suit could be brought about this. If you fire off a cease and desist letter and the other side perceives a tactical advantage to preempting you and filing a declaratory judgment action of non-infringement in their home forum or their preferred home court, you may have dealt yourself a self-inflicted tactical injury. Another concern with some infringers is that if you do send them a cease and desist letter, they go underground. They destroy things. They make it harder to find them. Sometimes that's just an inevitable risk. But what we've found, and I think Judge Bradley can go on and on about this too, is that if you catch somebody saying something or doing something in the marketplace and or on the internet that is really bad, right, and you have every expectation that's going to continue and they're shifty, right, there is merit to considering filing, maybe not necessarily serving right away, but filing a lawsuit when you've got them, when you've got the smoking gun evidence of them trying to pretend to be you, okay? Because if you can take that picture, that snapshot, so to speak, put that in your lawsuit, even if it's not a lengthy complaint, and get that on file, you have frozen in time this situation at a very advantageous one for you. I mention that because, while there's also a natural inclination to send a cease and desist letter and to hope and expect that the other side will find religion and will step back and clean up its act, right? Time and again, we've seen, particularly with smaller players, what somebody who's on notice but not yet been sued will do is make cosmetic changes in an effort to insulate themselves from a potential lawsuit. So it's a judgment call ultimately for you to make. We can understand that you may not want to just jump the gun and draft and file a lawsuit with the attendant expense until you really know that it's worth it. But keep in mind that consideration. So, a word about basics about hiring counsel, right? As I said, there are a lot of really good litigators out there. There are a lot of really good trademark lawyers out there. There are fewer really good trademark lawyers who are really good trademark litigators, okay? So that's a consideration. I can now say, as somebody who's been a member of the patent bar for going on 15 years, there are plenty of patent lawyers in the United States who are outstanding patent lawyers, but they also think that they are great trademark lawyers, and they're not, okay? So I can't tell you how many times I've had the pleasure of politely informing some of my patent law colleagues who are full-time patent lawyers, keep your day job. Leave the trademark litigation to the specialists. That being said, there are smaller firms that have people who are really good, know the local courts, know the judges, so that doesn't mean you necessarily have to go to big law, global law firms, even though that's clearly the best thing to do. So we talked a little bit about evaluating the scope of the problem. Is this matter that you've come across a bet the company name or bet the company logo question? In that case, it may be worth it. Abercrombie & Fitch has not had great press lately, but the first trial that we had was one such case where Overstock.com had essentially absconded with the famous Abercrombie & Fitch Moose logo and was putting it on inexpensive sportswear in sizes that Abercrombie & Fitch did not offer at that time. And so the company understood there was a reputational risk that warranted that. In other matters, maybe the market issue is not a bet the company logo situation, so you can do this in a more cost-effective or a less expensive way. So once you've identified some potential counsel, run a conflict check, lawyers are used to doing this confidential, you're not giving away state secrets by sharing with them the names of potentially adverse parties so that they can confirm that they don't have any conflict on the other side and that they can help you. You can call up, you can have a Zoom call and eyeball prospective counsel to see what you think of them, right? We talk about setting expectations in terms of money. It depends on the client. Some clients expect a fixed budget for every matter. Other clients, including clients I've served for 30 years, have never asked for a budget. It's a question of trust. It's a question of reputation. So really a judgment call, right? Before any lawyer can proceed in helping you, they're required by ethics rules to have a written and signed engagement letter, so you want to obviously look that over and then arm your counsel with the relevant documents. And it's not just the good, it's the bad and the ugly as well, right? The only way for your counsel to be of optimal help to you is if they know the whole story, right? The last thing you want is to just view the lawyer as a cheerleader who is to be provided with all the good news and then have something blow up in their face at the first appearance before the judge and completely tank your case when, in fact, if he or she had known about it in advance, there would have been full opportunity to vet that and come up with a really good response that essentially put the issue to bed forever. Okay. So very briefly, these are sort of the earliest stages that we've been talking about, right? In some cases, a petition to an opposition to a trademark that's been published for opposition or a petition to cancel the registration can be sufficient deterrence or threat to the infringer to back off, right? That being said, obviously, the PTO does not have injunctive authority to stop infringing use. So while there are plenty of really good trademark lawyers who focus on prosecution, they tend to be focused on just that, on cancellations, oppositions, and so forth. And frequently, that's a great pressure point that can bring you the ultimate relief you want from the marketplace. But a petition, a cancellation or a successful opposition is not going to stop use necessarily if the infringer is intent on going on. So one last point, I see we're out of time. One tactic that we found very effective and cost effective is that if you get through this process and you've determined, okay, I'm going to hire a lawyer to draft a lawsuit and file it, consider filing it first, because once you've done that, you've secured your jurisdiction of choice, unless it gets transferred out, and they seldom are, right? But once you've done that, consider sending the other side a courtesy copy under a letter from your in-house or outside lawyer saying, we're serious, you've got X days to stop, if not make recompense, or we're going to proceed with this litigation. That is frequently a time when infringers wake up and become reasonable. And that's before. You can always escalate later by within 30 days, depending on the jurisdiction, go ahead and serve your lawsuit, which then starts the clock on their time to answer. So that's essentially it. Time is up, and I won't keep you here. But essentially, this is what would lie before you if the case went on from there. Be thinking about any potential counterclaims. You don't want this to be a complete nightmare. The only way to get rid of a case early on, or at the outset, by motion to dismiss, is if the defendant can show that all the facts in the lawsuit, if they're assumed to be true, nevertheless don't entitle you to legal relief. It's a very tough standard, one that is very frustrating for foreign companies and clients, but be aware of that. I think I'll stop there, Holly and Amin, in case anybody has questions. Thanks for your time, and good luck on protecting and enforcing your registered trademarks. Uh-oh.
There's a microphone right here for you.
Okay.
Okay. So this is one question that came from one of our attendees online. So I have used a one-word trademark for over 25 years for a band. Other artists have tried to add a word or letter to my trademark for music offerings, goods and services. I've sent cease and desist letters, but still their sites remain and they appear in the search engines before ours. We are losing the strength of our mark. What can we do? What can we do, attorney?
What you can do,
Is hire you?
what you can do is if you, it sounds like they don't have in-house counsel. What you can do is hire a lawyer to spend a couple hours looking at this, right? Because it's impossible and frankly malpractice to advise any company in the abstract. I understand the fact pattern generally, but the answer can vary widely depending on whether the name of their band is Nirvana 2 or Ipswich Sandwich, right? So, but a good lawyer, a good trademark lawyer, within a couple hours, 3 or 4 hours, ought to be able to survey the situation and give some directional advice on whether they need to change their name or whether there's good ground for going after the other worse band.
Great. Thank you so much.